Good afternoon and welcome. I am Mark Wilson, Director of the Caroline Marshall Draughon Center for the Arts and Humanities in the College of Liberal Arts at Auburn University. Today is Constitution Day, September 17, the anniversary of the signing of our nation's founding document. If you're in, see a few Auburn University students walking around campus wearing these t-shirts because they participated in recorded interviews related to the Constitution and the rights and responsibilities of active citizenship. Or you might see some members of Auburn's Osher Lifelong Learning Program wearing these shirts because they contributed essays and memories on a constitutional amendment that has special meaning to them. We'd like to thank 7th grade students at East Sanford Middle School for reading and judging those essays this week. And you will find a link in the comments section on Facebook where you can read these essays as well and congratulate the winners. Special thanks to social studies teacher Blake Ramsey for organizing a class of 7th grade judges, and to the David Matthews Center for Civic Life for their collaboration on that unique project. And now we have a special opportunity with the Judge Frank M. Johnson Jr. Institute, which was founded in 2019 to promote understanding of the U.S. Constitution, the independent judiciary, and the impact of the rule of law on our lives. Our host will be Executive Director, Mr. Thomas Raines. Mr. Raines is originally from Atlanta, Georgia, but he was raised in Birmingham and Lynette, Alabama. He holds a Master of Public Administration from Columbia University and dual bachelor's degrees in history and journalism from Boston University. He has worked as a middle school teacher in the Mississippi Delta, a journalist covering finance in New York, and a researcher of politics and policy in Washington, D.C. The Johnson Institute is located in Montgomery. The Institute's educational programs honor the life and work of Judge Frank M. Johnson, who served as a district court judge in the U.S. Court for the Middle District of Alabama from 1955 to 1979, and a judge on the U.S. 5th and later 11th Circuit Court of Appeals from 1979 to 1999, when he took senior status in 1991. Among his many honors, he was awarded the Presidential Medal of Freedom in 1995. You will definitely learn more about Judge Johnson's work and legacy today, and we will welcome your questions in the comments section on Facebook, which we will get to later in the program. Welcome, Mr. Raines.
Thank you, Mark, and thank you to the Draughon Center for Arts and Humanities and Auburn University for co-hosting this event with us. As Mark said, the Johnson Institute is a nonprofit founded last year. We are taking advantage of the unique opportunity to tell the stories of some of the events and cases that happened here in Montgomery, Alabama. Judge Frank Johnson was 37 years old in 1955 when he became a U.S. District Judge. He had been nominated by President Eisenhower, and 6 months later, he was faced with deciding the constitutionality of bus segregation in the case stemming from the events that began the Montgomery bus boycott. Along with Rosa Parks, Dr. Martin Luther King, and so many others, Judge Johnson helped to change the world from right here in Montgomery through his constitutional rulings. By standing firm, the cases he decided would help to dismantle Jim Crow and affect the nation and the world. In the Johnson Institute's programming, we like to highlight stories of justice from history, often discussing Judge Johnson's impact and his courage. We do this to promote understanding of the Constitution and the independent judiciary and the impact of the rule of law. If you would like to stay in touch with us, I encourage you to. We are on Facebook, as I know many of you are watching today through that, on Instagram, Twitter, and LinkedIn. And you can also visit our website and make a donation at thejohnsoninstitute.org. We have a great program for you today with two distinguished guests that it is my honor to introduce. First, we have Honorable Magistrate Judge Susan Russ Walker. Judge Walker was sworn in as U.S. Magistrate Judge in 1996. She graduated with highest honors from Eckerd College, and after a year of graduate work at the University of Virginia, she attended Oxford University on a Rhodes Scholarship. Judge Walker received her law degree from Yale Law School. She clerked for Judge Johnson on the 11th Circuit Court of Appeals. She served as Assistant Attorney General for the state of Alabama, and thereafter as a partner in private practice until her judicial appointment. Judge Walker served as Chief Magistrate Judge from May 2008 until February 2017, and she is currently a member of the Board of Trustees of Eckerd College, and she regularly teaches both mediation and law and literature to fellow judges for the Federal Judicial Center. Next, we also have Peter Canfield with us. Mr. Canfield is of counsel with Jones Day, based in the firm's Atlanta office. He is a graduate of Amherst College and Yale Law School. Prior to entering private practice, Peter clerked for Judge Frank Johnson on the Fifth Circuit Court of Appeals, U.S. District Judge Myron Thompson here in the Middle District of Alabama, and Peter served as an attorney with the Civil Rights Division of the U.S. Department of Justice, a special assistant special assistant U.S. attorney in Washington, D.C., and a deputy DA here in Montgomery. Peter is a founding director of the Georgia First Amendment Foundation, and he has been a director of the New York-based Media Law Resource Center. Peter's list of clients is extensive, too extensive for me to list entirely, but they include, among others, ABC, CBS, ESPN, National Public Radio, the New York Times, the Times of London, the Washington Post. He also, in addition to his non-media clients, like national advertisers, including Sprint, and educational entities like Emory, and dare I say, during an Auburn University presentation, the University of Georgia. Judge Walker and Mr. Canfield, on behalf of the Johnson Institute, thank you both for joining us today. You both have quite impressive biographies, and many of the folks watching today are students. And to get started, I would like to ask you if you could tell us about your career and how you got to where you are today. And as part of that, if you could tell us, in honor of Constitution Day, when you first recall becoming interested in the Constitution and the law, and how that has played a role in your career interest and your journey. And Judge Walker, I'd like to start with you.
Sure, thank you, Mark and Thomas both, for inviting me today. I'm delighted to be here. So to try and answer your question, I can tell you that one of our judges here says that she grew up with fan posters of Supreme Court justices on her bedroom walls, and I'm convinced that she was probably born with a copy of the Constitution in her hand. But that was not at all the case for me. I'd like to impress you with my early devotion to the field, but the truth is, I didn't know any lawyers when I was growing up in East Tennessee, and I had absolutely no interest that I can remember in the law. I mean, I think I did have a civics class in middle school, and I'm pretty sure I registered the fact that the United States had a Constitution and a Bill of Rights. But I just don't remember thinking any more about that other than that those seemed like very nice things to have. I went to college at a small liberal arts college in Florida called Eckerd College, where all my brothers and sisters had gone before me, and I majored in English literature. I like to read and write and do research, and I found that I actually loved authors like Shakespeare and John Donne and Andrew Marvell and many others. So I actually did graduate work in English at the University of Virginia and then at Oxford. But all of the time that I was studying, I mean, this was happening in the 1970s and the early 80s, when civil rights and women's rights were in the air. And I really just felt like maybe there was something missing for me. Those were things that I cared about, and I wanted to work on them. And I became convinced that law school would give me the skills that I really needed to do that. And what probably cemented that view for me was the fact that my mother, who had polio before I was born and used a wheelchair for the rest of her life, was back in my hometown all that time that I was studying, quietly leading her own campaign for disability rights. And those were simple as the right to accessible parking spaces and restrooms and other public facilities. And she had more intelligence and commitment than anyone else I knew. But without a law degree, I think her work was really much, much harder. So ultimately, I changed my focus. I went to Yale Law School. And then I was fortunate enough to come to Montgomery to clerk for Judge Frank Johnson. By that time, had become nationally known for his courage and his skill as a judge in cases that concerned really some of the most important issues of our time. And then after clerking, I decided to stay in Montgomery. I married. I practiced law for around 7 years. And then ultimately, I was appointed a magistrate judge in the Middle District. And I've had this job for almost 24 years.
Judge Walker, thank you for that. Thank you for telling your story. Peter, we were having a few technical difficulties earlier. Peter, can you hear me? Are you online now?
Yes, I am online. Can you
hear me? Thank you so much. Good to see your face and hear your voice. Would you tell us about your own career and your own journey?
Sure. I think much like Judge Walker, I am not someone who grew up thinking or knowing that I wanted to be a lawyer. There weren't other lawyers in my family when I was young. Never really had any connection with them. The way I got to the law is that I always as a kid was interested in news, and that got me interested in newspapers, of course, at the time. And so both in high school and in college, I did a lot of work with my high school newspaper and then my college newspaper. And I think I did it because I always had this interest in trying to understand why things are the way they are. And I always felt that trying to myself explain those in writing helped me better understand the way things were. And so I really enjoyed being a reporter. I enjoyed the fact that you got to meet and ask pointed questions to people who were sort of in the middle of what was happening, and having them answer those questions and then trying to explain it to a broader audience. I think that I never had great confidence, though, in my ability to do that professionally. I just didn't feel like I was as compelling a writer as perhaps you needed to be an effective reporter and journalist. And so as college was ending, I thought, well, a lot of people were interested in law school. Law school it seemed like a pretty good alternative, at least to explore for a while, because you also got to ask people questions, and theoretically you could even make them answer them. So I went into law school. I very much enjoyed law school. I wasn't sure, though, at the end of it that I wanted to be a lawyer. I still toyed with going back into journalism, but that really changed when, like Judge Walker, I got the opportunity to clerk for Judge Frank Johnson and come to Alabama. And clerking for the judge and being in Montgomery, in a place where so many important decisions had been made that affected so many people, really, I became a believer in the law and the ability of the law to affect change. And I think as part of that, thought, well, I could see myself, being a lawyer the rest of my life. And so that's where it started for me.
Thank you. That's wonderful to hear from both of you, and thank you for telling us about your own experiences. I'd like to move into some more specific questions for each of you, and I'll start with one of you. I'll address the question to one of you, but if the other wants to add anything, please do. Please feel free to jump in. I hope this can be a conversation. And for those of you watching, if you have a question, if you can type it in the comment box. We will try to save some time at the end for questions. from you all, and Mark will come back on and help us with that toward the end of the program. Judge Walker, can you tell us more about your role as a U.S. Magistrate judge, and how does that role differ from that of other judges, federal, state, local, and other roles similar to that?
Sure. I think maybe magistrate judges are not as well known. The role of magistrate judges is not as well known as others. We are the first level of the federal judiciary. We're appointed under Article 1 of the Constitution rather than Article 3. And at the next level are the district judges who are appointed under Article 2. And together we make up the trial court. So that's the court where you would expect to hear testimony and other evidence live in a case first, and where the outcome of a case is initially determined either by a judge or a jury. The two levels above us are both appellate courts. First, the Court of Appeals, in our case, the 11th Circuit, which covers Alabama and Georgia and Florida, and on which Judge Johnson served, and we and I both clerked. And then the United States Supreme Court, obviously. And in the appellate courts, of course, the parties bring claims of error in the lower courts. They tell the circuit courts how we erred on appeal. Magistrate judges are appointed by the district judges for fixed, renewable terms of 8 years. And we are selected after review by a merit selection panel, which is usually constituted, made up by people in the community and lawyers. But we're selected by the district judges based on merit only. There are about 500 or so of us in the country. All of the other judges I mentioned are political appointees who are nominated by the president and confirmed by the Senate for life tenure. Magistrate judges are the judges whom litigants probably see the most in court in person. Federal criminal cases are cases, these are just examples, but like large drug distribution conspiracies, weapons possession by convicted felons, bank, wire, tax, healthcare fraud, child pornography, bank robbery, those kinds of things. It's the state courts that have the rape and murder and robbery cases, cases of that kind, as well as on the civil side, car wrecks, property disputes, divorce, custody matters, those kinds of things. And there's overlap on some of these matters in the federal courts and federal system. And then local courts usually hear smaller offenses like traffic tickets and shoplifting, leash law violations, things of that kind. And I don't want to go on too much, but just briefly, what we actually work on is this. The magistrate judges handle all of the preliminary appearances and motions in felony criminal cases. That includes search warrants, criminal complaints, suppression motions, guilty pleas. And we have ourselves substantial dockets of misdemeanor and petty offense cases as well. Some of these matters require us to prepare written recommendations to the assigned district judge. Many do not. We also have full responsibility for many civil cases by consent. Those tend to be, but maybe the majority in this court, discrimination claims, especially in employment, cases brought by prisoners who are in charge of disputes about discovery. We handle mediations, we handle naturalizations of new citizens, and really a host of other things that are far too numerous to mention. But suffice it to say, it is a very busy job.
It sounds like it. Thank you so much. And Peter, much of your work as an attorney is related to the First Amendment. And for those who are watching who are not familiar with the legal world, what does that mean? What kind of cases do you handle in your work?
Sure. Well, most of the work that I've done in that regard has been work for news organizations. And what First Amendment work means for news organizations is really they look to their lawyers to help protect them I mean, as reporters, they're people who want to speak out. You know, as I mentioned, you know, that what the news is devoted to is to find out what's going on and to report that in a way that people can understand it. And so the kind of legal issues that come up the most are first helping those news organizations get access to the information they need, and they have a important series of rights that enables them to do that. So, for example, I mean, typically with most stories, there are some people who want that story told and some people who don't. So oftentimes there are people who want to make it hard for the reporters to get the information they need to report the facts. And a lot of times that involves, as a lawyer for them, helping them get access to that information. A lot of it is maybe government information in the form of government records that show what government officials have been doing or not doing. It may involve getting access to court proceedings. So you have that side of it, which is helping the media get access to information. The other side is helping protect them and their ability to report on that. And, that comes up in a number of different ways. One way is to help, for reporters, even though when they eventually report a story, their sources for it hopefully will be clear and stated on the record. But in the course of getting those stories, they often have to talk to people who don't want it to be known that they're talking to them. And so having the ability to have some breathing room in that news gathering process is important. So another aspect of the job is protecting reporters from subpoenas that try to get into their sources and source relationships in a way that if it were allowed freely would make it very hard for them to do their jobs. And the last major legal area is trying to protect news organizations when they are ready to report or have reported the stories that they've been working on. So that can involve defending against attempts to stop them from publishing, which we've seen more of than usual in recent years. It can also involve efforts to protect them in court if they're sued over what they publish. It's claimed that they've libeled somebody or invaded privacy. I mean, one of the most, this was not a Judge Johnson case, but one of the most important cases in First Amendment jurisprudence was decided in Montgomery, came out of Montgomery State Court, but was eventually decided by the U.S. Supreme Court, and that's a case called New York Times versus Sullivan, which held that reporting on public officials is constitutionally protected. Even if there are mistakes in that reporting, those mistakes won't lead to liability for that news organization as long as the news organization didn't know that those mistakes were being made when they publish. So that gives you a sense of the range of the kind of media First Amendment issues I've dealt with in the course of my career.
Thank you, and thank you for mentioning Times v. Sullivan. That is one that, having been in journalism for a little while myself, and familiar with it, not as familiar with you are. And the term "without malice" comes to mind. Is that correct? The test for news organizations?
Yes, it was Times versus Sullivan that established this actual malice test, which said that if you're going to try and recover damages from a news organization for reporting on a public official, you have to show not only that they published something that was false, but they published it with actual malice, which means in this context that they knew it was false or had serious doubts about its truth when they published it.
Thank you. Thank you. So each of you clerked, as you mentioned, clerked for Judge Frank Johnson, which this institute is named after. Judge Johnson decided cases that had a significant impact on the history of the United States. And I'd like to ask you each about this. Judge Walker, I'd like to start with you because I've got a quote that I think will resonate with you as a judge yourself. There's a quote from Judge Johnson that says, "I was not hired to be a moral judge. I was not hired to be a preacher or an evangelist. I'm hired to apply the law." What do you think he meant by that? What does that mean to you as a judge?
So maybe despite what many of us hear in the news about so-called activist judges, in my experience, most federal judges have a very acute sense of the limits of our role. When we do decide only cases that come before us, we don't go out and actively solicit them. We are indeed required to follow the law in those cases, and our personal views and beliefs should not influence the results. I mean, that said, of course, we are, at least arguably, human beings, and it can be difficult to remain utterly neutral and dispassionate about a case. And in fact, the law can have multiple interpretations about which principled people can disagree. But it is an absolutely constant and critically important discipline for judges to remain neutral and to do their best to respect the separation and limits of powers, or power in a democracy, to the extent that we know how to do that. We're not elected legislators. And personally, I can tell you there have been more than a few times that I've disagreed with the result, that I had to reach an opinion or an order, but that is what the job entails, and that is what Judge Johnson is referring to, because his rulings, especially in the area of civil rights, were so controversial, many of them, in their time and place. And in some cases had to be really broad and sweeping in order to fully vindicate the constitutional and also statutory rights that were at issue. I think he took even greater pains than usual to make it clear that he was not on a personal crusade. He really was applying the law as he understood it. And in that regard, to me, he was a great patriot. He had tremendous respect for the Constitution and laws of the United States. He demonstrated that respect daily at a very high personal cost, which I certainly have not had to experience in the same way. He was one of the most principled and courageous people whom I have ever known.
Thank you. Judge Walker, I'd like to come back to you in just a second and follow up on something you just said around the personal cost of Judge Johnson. But before we do that, I want to turn to Peter and ask, which cases decided by Judge Johnson stand out to you as particularly relevant today in the history of the United States?
Well, there's so many, it's difficult to single out just a few, because his decisions were really landmark decisions in so many different areas, and ranging from the Montgomery bus boycott case, which people think of as the Rosa Parks case, that he was part of deciding just after he first assumed the bench, through his other, civil rights decisions involving the Selma March, protecting the right to do that march, in areas of rights of the mentally ill, prison rights, prison conditions, mental health, asylum conditions. He was, I think, one of the first to find that women had a right to serve on juries. So his decision in the Hardwick case really Although it was reversed, the Supreme Court then later reversed itself in effect a few years ago in Lawrence v. Texas to protect, those rights. So there's so many, there are so many cases. It's hard to single out any. What I thought was really distinctive and most impressive about him it's a care that Judge Myron Thompson I know exercises all the time, and I had the privilege to clerk for Judge Thompson after I clerked for Judge Johnson. But it was the way Judge Johnson approached cases that I think is most relevant today. He didn't reach out to decide cases or issues that weren't before him. But when a case was properly brought before him, he didn't shy from resolving it. And for him, that meant not just declaring a winner or a loser, but actually where there was a wrong being done, not just flagging that wrong, but I think he felt a real responsibility to give effective relief. And that is something that is can be extremely difficult to do. We see so often decisions that get made today, but they don't seem to really, the law in some ways can sometimes seem so slow and plodding that it can be, the relief comes long after it's needed. But in his case, he just took a lot of time to make sure that not only the rights were declared, but that relief was given. And so, for example, he had a school desegregation case statewide in Alabama that he spent years on to effect. But this was really true in every case. I mean, there's a story told about the Selma March case, that when he reached his decision to let that march resume, which was a major thing to, in effect, close down the main highway, close down most of the main highway, or interrupt it between Selma and Montgomery for the period of time that it took to walk from one to the other. Before he actually entered that decision, after he'd heard all the testimony and had decided what he wanted to do, he first made sure that the federal government would be there and would be ready, was ready and willing to enforce his order. He also made sure that if the state wanted to appeal it, as they did, he went ahead and arranged for a hearing time to be set up before the appellate court, which was then the Fifth Circuit in New Orleans. And he not only did that, but he checked with the airlines to see when the flights were from Montgomery to New Orleans, so that the lawyers from the state and the marchers in the U.S. could get there for the hearing. So that when he announced the decision in chambers, he said, if you want to appeal this, they're set to hear from you in New Orleans at this time. You can get a plane, from the airport here and be there at this time, so you'll have time to get there. And the story that was told is that when he told the lawyers that, one of the lawyers from the state said, "Well, Judge, did you go ahead and make reservations for us?" He just planned, he thought through things, planned them out, and made sure that that when he issued an order, it wouldn't be something that would, just be words on paper, but that it would actually lead to effective action. And I think that's, a very distinctive legacy of his that often doesn't get enough mention that it should.
Thank you for that. And Judge Walker, you mentioned a moment ago the personal cost to Judge Johnson, and this is a panel discussion on the Constitution, and so I want to come back to those questions in a minute. But I did want to acknowledge that because the personal cost to Judge Johnson was significant. And could you tell us a little bit about that and what he dealt with in his life as a judge here in Montgomery, Alabama? Ruling often ruling in civil rights cases that changed the way society functions here in the South.
Sure. Much of what I can recall about that did relate to in particular to the period in which the most difficult civil rights decisions issued from this court. And so, especially in the 1960s and early 70s, and really from the time he got on the bench, which was, I think, around 1957. So he received death threats. He was ostracized in society in Montgomery. I think since Judge Johnson was from the country and up in North Alabama, he was sometimes not so concerned that he wasn't necessarily welcome at the country club. But nevertheless, he was not a popular figure. He was pilloried by the governor frequently and in some quite colorful language. My recollection, if I'm right, is that he had a cross, a burning cross placed on his lawn following the decision involving the buses and the Rosa Parks, the one related to Rosa Parks, though it's called Browder versus Gale, and involved other plaintiffs. I think his mother's house was bombed. She was okay, but that happened as late as the late 1960s. He had protection by federal marshals more than a decade, maybe even close to 2 decades, which meant marshal service was at his house all the time. And one of the things that I remember specifically was the difficulty with his church. He was a member of the First Baptist Church and really was not welcome there. And it wasn't until much more recent times that I believe the pastor there reached back out to Judge Johnson, perhaps even apologized on behalf of that church, though he wasn't there then, and tried to make that right.
Thank you. Thank you for talking a little bit more about that. Judge Walker, you were a magistrate judge here in the Middle District of Alabama, which covers sort of the southeastern part of the state. And throughout history, as Peter has mentioned in particular, there have been a number of historically significant cases involving the Constitution that were filed right here. What cases come to mind for you, and what was their significance not just for Alabama, but for the United States?
I could talk about so many, and Peter has referred to lots of them. Judge Johnson's mandating desegregation of bus depots after John Lewis and the Freedom Riders came through here and actually testified here in this court. Desegregating public libraries and agricultural services and the whole public school system in the state of Alabama, prohibiting gerrymandering of district lines to dilute black voting strength, finding state legislative districts drawn unequally and compelling Alabama to re-abortion, ordering the desegregation of the local YMCA, requiring racial parity and the hiring of state troopers, and so forth. You could really go on and on. I should say that in some of those cases, Judge Johnson was not the only judge participating. It's important to acknowledge that sometimes those were 3-judge panels, and he would be joined, for example, by Judge Richard Reeves, another judge who deserves a lot of credit for some of those decisions, and for whom he had great respect. But because so many of Judge Johnson's most famous cases involved race discrimination, I actually do like to remind everyone from time to time that he was also involved in some important gender discrimination cases. And for example, one of those was White versus Cook in 1966, decided by a 3-judge court, in which the court ruled that the state of Alabama had to allow blacks to serve on juries, but also that women could not be prohibited from service based on gender. In the state of Alabama, and throughout the country, in fact, obviously women couldn't vote for a long time. My grandmother, when she was born, that was the case. When my mother was born, women in Alabama at least could not serve on a jury. That didn't change until this case, White versus Cook. There was actually a law in Alabama that prohibited women from serving on juries. And this case, White versus Cook, represented the first time that a federal court ruled that the 14th Amendment of the Constitution prohibited sex discrimination as well as race discrimination. As recently as 5 years before that, the Supreme Court had said that a woman is regarded as the center of home and family life, and it was not wrong for a state to exclude her from compulsory jury service for what it called the general welfare. So Judge Johnson and that panel was ahead of the Supreme Court, and that was true for many cases. And I'll just mention one other quickly. It's not a not a constitutional case, but I think it's important to recognize that the federal anti-discrimination statutes followed much of the logic of the Constitution and much of the jurisprudence that evolved around the Constitution. And so this is a statutory case, but Weeks versus Southern Bell in 1969, in which Judge Johnson was sitting with the 11th Circuit by designation, involved the application of a woman at Southern Bell to be a switchman. And she was told that only men could be hired for that position. The rule was that women couldn't be made to lift anything heavier than 30 pounds. That's what the job required, they said, so she couldn't do it. And Miss Bell was lifting her typewriter every day to put it on her desk from under her desk. It was over 30 pounds. The children were probably heavier than that. She filed a lawsuit under the Civil Rights Act, claimed that she was the victim of discrimination because she was female. She lost in the district court. Judge Johnson wrote the opinion in the appeals court, and obviously found to the contrary, and ordered that she could take the test for the job, that she passed. She got the job. She got back pay later. Another example of a decision in which Judge Johnson was a leader in the country and followed by many others this time.
Wow, Peter, thank you so much. I want to turn and ask a couple of questions about the Constitution itself. Peter, over the years, our country's interpretation of the Constitution has changed. For example, the Supreme Court came to very different conclusions when they decided Plessy v. Ferguson in 1898 compared to Brown v. Board of Education in 1954. How could they have read that differently? What has changed in our country or with the court?
Well, I think it's hard to explain that change other than by reference to community, the sense in the community and the country at the time. And I think it's useful to look at, there's a very famous and often cited study that was done of the US and the racial problem in the late 1930s by a Swedish social scientist named Gunnar Myrdal. And, he and a team of researchers spent a lot of time in the US talking to people, and then they developed this report that he published. And in it, he concluded that I think, as we all believe, that America, probably more than any other Western country, has long had this, what he called, a living system of expressed ideals for human cooperation, which was unified, stable, and clearly formulated, in our Bill of Rights and otherwise. But he said the problem with respect to race and why that didn't translate was knowledge, that there just was astonishing ignorance about the racial issue on the part of the white public in the North. In the South, it had become so ingrained that it wasn't even so much. It was sort of, in a way, taken for granted. And he said that really the solution for that was to get publicity and to make people around the country aware of what was going on, so that it was too painful to ignore it anymore. He referred to something that he called the, quote, opportunistic desire of the whites for ignorance, that people want to be ignorant about things that might disturb the status quo. And I think what happened in the country is that there were changes. Things happened that made it clear to people, both by the time of Brown versus Board of Education, when you had, people returning from, veterans returning from World War II who'd fought for our country there, and then they'd come back to the U.S., particularly the South, and be treated like second-class citizens. And I think those kinds of things led to Brown versus Board of Education, and led further to the kind of change that was brought about by the rest of the civil rights movement as it moved, through the 50s and into the 60s. That was the change, I think.
It was fascinating. Thank you. Judge Walker, when the Constitution was signed 233 years ago today, on September 17th, 1787, the world was quite a different place. Monarchies were more common than democracies and republics. What led our founders to agree on this radical idea for the basis for our system of government here in the United States?
So, Thomas, the answer to that question, if I were really to do it justice, and maybe this is appropriate for a presentation by a Center for Arts and Humanities in part, would require me to try to recite a history of the Enlightenment, which I'm not sure I'm qualified to do. But that was a genuinely remarkable 18th century attempt to apply human reason to government, politics, science, philosophy, a host of other fields. And the roots of that, in turn, were, at a minimum, in the humanism of the Renaissance, with the revival of the study of classical literature, in the Protestant Reformation, in which many were questioning received religious dogma, and maybe the most important source was this sort of notion of empiricism that had been introduced by people like Bacon and Copernicus and Galileo and Descartes in the study of science and mathematics. The ideas behind all of these movements, if I had to generalize, was to project received authority to the critical attention of a free mind, of an educated, free mind. And I think the founders of our country were strongly influenced by these movements, and they were reading a lot of political philosophy, especially writers like Locke and Montesquieu and Hume, and there are lots of others. They were really well educated. They were intensely interested in ideas. This is the story of the history of ideas. And they were particularly interested in the idea of republicanism. At that time, I think, very much still a radical ideology. And so their opposition to monarchy and to hereditary aristocracy went all the way back to their study of ancient Rome and the Roman Republic. And what they learned, all of that thinking and talking and reading and studying, generated ideals that they didn't put into practice perfectly. Witness the institution of slavery, the original sin of the Republic, and also, as I mentioned not long ago, the exclusion of women from much of civic life and many other issues. But those founders also got a lot right. And all I can do is commend to everyone, to the extent that you can, to look at what is a very big topic, the political philosophy of the Republic and what led up to it. And I don't pretend to be an expert on it, but that's my understanding of some of what was involved in how we came to be where we are today.
I think you are certainly an expert for that many of us look to for these kind of answers. I'd like to ask you each one more question and then finish with a final question for both of you. And then we'll have a little bit of time for a question from the audience, from the viewers. Peter, free speech is enshrined in the Constitution, in the First Amendment, and these days we seem to hear a lot about it in the public realm, in our public discourse. The importance of free speech, the right to free speech being abridged. What's your take on that? What's happening? Is something different today? Is it? Are we just hearing more about it? What's happening?
Well, I think it's always been important. I think it is especially important these days. I think, as the country has become more divided on partisan lines, it's we don't have as many shared sources of information that we all agree are objective and important. And I think that's a very bad thing, because I think we need facts and information and ways for messages to get out and what's actually happening to get out in a way that everybody can have a consensus about it. And with technology now, we get a lot more of it in a way that's raw than we used to. And in some ways that can be very powerful and good, but it can also be, if it's manipulated as video and other things can more easily now be manipulated, that's dangerous too. But the reason it's so important is, to go back to the discussion of the civil rights movement again. I think there are problems. What happened in the 60s, I believe it's correct to say, is that the kind of racial injustices that were regularly occurring, events like, the beating of the marchers on the Edmund Pettus Bridge, which literally was shown to the country in the middle. One of the television networks interrupted the movie of the week that was playing that Sunday evening, which happened to be Judgment at Nuremberg, about Nazi Germany, to come in with 15 minutes of video of those horrible beatings of John Lewis and others. And I think it brought home to people in a way that things like the George Floyd tape has brought home so clearly to so many people this year, that there were injustices that were being ignored and that shouldn't be ignored, and that led to change. And recognition of First Amendment rights is very important to that. John Lewis himself used to say that the civil rights movement couldn't have done what it did without the media that was watching them, and was protected by decisions like New York Times versus Sullivan, which was really a civil rights movement case in a way. The issue in that case was literally an advertisement about things that had happened in Montgomery in the course of the civil rights movement. It was critical to having change come about back then, to have the media there and be able to report it. I mean, John Lewis used to say, if it hadn't been for the media, and this is a quote from him, the print media and television, the civil rights movement would have been like a bird without wings, a choir without a song. So it was important then, it's still very important now.
Wow, thank you. Thank you for sharing that. Judge Walker, the Constitution guarantees us certain rights, as we know, as citizens: free speech, the right to vote, the right to a fair trial, and many others. But the rights guaranteed also come with responsibilities. What does this mean, and what are some of the responsibilities that we have as citizens?
I think maybe most importantly to educate yourself about government and politics, about current issues, to participate actively in government. There are still very direct methods of citizen participation on a petty jury, a grand jury. Those are governmental functions that individuals have the opportunity to experience. To speak out and even to assemble where it's appropriate, to exercise First Amendment rights that Peter was talking about in an informed and in a responsible way, to vote, and make sure others have the opportunity. The roots of these responsibilities, and I think there are probably others, actually go back to the concept historically of civic humanism. And this is, again, return to the Renaissance, and to Machiavelli, and to other political philosophers. There were classical Republican virtues that included selflessness and independence and concern for the public welfare and for equality and for virtue. And again, some of those ideals have been honored in the breach, as we discussed. But as time has passed, and those concepts have continued to evolve. And they do evolve through the continued exercise of and our continued thoughtfulness about our civic responsibilities. And that's why a program like today is, I think, important, and why I'm grateful that students and others are interested in at least beginning to think about these issues and continuing to think about these issues.
Thank you. We are running up close on time, so I will ask Mark if he can jump back on to moderate any questions we've got from the viewers. But while we're doing that, I'd like to ask you a final question from me. Many of the people watching this panel today are students who are going to begin their adult lives in the next several years. What advice do you have for them as they enter adulthood and enter the world as, I guess you could say, full-fledged citizens for the rest of their lives? Peter, can we start with you?
Sure. I very much would echo and second what Judge Walker just said. I think to be engaged is very important. Exercise the rights you have. I think I'm in one. I've been encouraged by the extent to which, despite all the challenges we faced this year, people, when they've seen disturbing things like the George Floyd video and others have we've seen many people come out in a way and to peacefully protest that I think has been quite encouraging. I'm also encouraged that I think younger people are becoming much more sophisticated than certainly our generation at filtering what goes on in like social media and other places, including various different kinds of news media. They become much more adept at figuring out what is really true and what is, and what is noise. So I'm encouraged by that. I think it's important for all of us to learn how to do that.
Thank you. Judge Walker, any thoughts for today's views?
Maybe a couple of thoughts to add to what Peter has said. I personally, I guess, as an English major, as a lover of history, among other things, would really urge students to think about including the liberal arts in your studies, history, literature, philosophy, art, and so forth. And college isn't all about your career. All of us need to learn how to think and write and speak critically. Those disciplines foster that ability. But we also have to learn as much as we can about how to live and how to be a humane and a thoughtful person. And indeed, as far as careers are concerned, the best lawyers and best employees often have those liberal arts backgrounds. And the biggest regret, typically expressed by people who are surveyed after college, is they didn't pay enough attention to their opportunity to study those subjects. And the only other thing I'd see is to think about applying some of the principles of the Enlightenment, some of what we talked about, to your own lives. One of those made most famous by Descartes is doubt, the principle of doubt. And we're also doubtful about our parents' views, but from time to time, but more broadly, just being skeptical about the truth of your own beliefs, about the received opinions we get from others, and subjecting those to scrutiny, and insisting on and acting on the truth as we can perceive it. And at the root of that, I think, is a really important principle of humility. The idea that we really don't know everything, that each of us may not be right. We can still learn from each other. And even if we disagree, we can do that in a manner that is kind and civil and thoughtful, and that shows genuine gratitude for the opportunity that we do have in this country to do that.
Thank you, Judge Walker and Peter, for your insight and your wisdom on this day, celebrating the signing of the Constitution. I have learned a lot. I know our audience has too. I think we have a few questions from viewers. Mark, can you help us with that?
Certainly, we do. We have 3 quick questions to round out our program, and you've answered some of these already. I want to give you a chance to specifically just give us a brief response. The first one is this. You'll see it on the screen. What recommendations do you have for undergraduate students who are interested in constitutional law? Peter?
I think Judge Walker just answered that question too. Obviously if you have that interest, you're going to end up in law school. But I think the best way to prepare for that is to think critically. Let your mind take you different places you're not sure of, and like history and the arts, and look at those and think about your own views and beliefs. And I think that's the best preparation you can have.
Thank you. Judge Walker, would you like to add something else?
I can only underscore what Peter said. Law school is plenty of time for that. You can still study constitutional law, and as an undergraduate for sure, but don't spend all your time on that yet. When you have the opportunity to do something much broader and more thoughtful, that exposes you as widely as possible. It's hard to understand questions in the law if you don't know enough about what is behind that and why we care about it.
Excellent. Thank you for that. And we might add that undergraduate students should find out about the Johnson Institute and get involved in its work too. And so another question related to Judge Johnson is this: what is one example that we could take from the life of Judge Johnson, especially in light of the struggles our country faces today? And I think I'll ask it even more specifically. Is there a court case that you think we should look at, or a particular period or a particular story? You've named some from the life of Judge Johnson. But is there something as further reading or further exploration that we should all look into following this program? Peter?
I don't know if there's a particular case I'd point to other than that. And again, this follows on what Judge Walker said. Judge Johnson was, I mean, if you look at his background, we haven't talked a lot about that, but, you know, he came from a very, you know, conservative, I don't know if that's the right word, but if you were going to try and pick someone who would be as influential and as important as he was, you probably wouldn't have come up with someone from where he came from in Northwest Alabama. And he had a lot of beliefs and you know, preferences that he brought from that he when he was in the courtroom, I'm not saying it very well, but he really had others have said it much better. He had an incredible way of putting himself in other people's shoes. And I mean, in line with Judge Walker said about, you know, we shouldn't always be convinced we're right and we should listen to other people. He really did try to think through what it would be like to be in the shoes of that other person, even if they were very different than he was, and act based on that, not based on some prior prejudices or whatever. Thank you.
Judge Walker?
Well, I would only add to that. He was a remarkable example of strength and courage and conviction. And we can say those words, they're almost platitudes, but when you see it put into practice, it's really remarkable. And I didn't vote for him back in I'm going to say not that old, back in the time of these most fundamental civil rights cases, but that carried all the way through. And it was brilliant. Also had an amazing sense of humor. He was incredibly down to earth. And I just think that sense of humor is also important to cultivate and character. That's not, neither of us has suggested a person to read, but just reading about the life of Judge Johnson, listening to his interviews, it would be really worth your time. And let me just add, the life of Ruth Johnson, his wife, who herself was an amazing individual, and it's so much fun. Her takes are so much fun for this.
Thank you for mentioning her as well. It's very helpful. Last question, and this one is specifically for our friends who are in 7th grade at East Sanford School in Auburn. They served as judges this week. We had a small contest of essays from our lifelong learning program that they had to judge. And so they had to rank and choose the most informative, the most inspiring, et cetera, in different categories. 7th graders. Why should 7th graders care about the United States Constitution on Constitution Day and beyond? We're recording this program and we'll be sharing your response to them. What do you say to 7th graders? Peter?
They should care because it affects their lives every day in ways they probably don't know now, but the more they looked into the Constitution and the rights we have there, they would understand.
Excellent, thank you. Judge Walker?
Well, we have students who come to our courthouse. They do mock trials here. They participate in other activities, listen to people like me. And what I find is that it's not about whether they should care or even why they should care, but they do care. They're really engaged. They're really involved and aware, and you know, they should care about trying to do a mock trial and being judges themselves, because it's a great dry rehearsal for what is coming next. They will be the people who will be leading this, and we look to them to make it better and also to carry on these most important traditions.
Thank you for that. And I think that that brings us basically to where we started from with your own stories about how you found the law, or maybe how the law and public service found you. And we're so thankful that that relationship happened and that your service has been shared with so many citizens around the country and beyond. And so on this Constitution Day, we thank you for participating with us, and we look forward to connecting with you again. Thank you, Thomas, and the Johnson Institute for making this possible.
Thank you, Mark, for helping us put this together. Judge Walker and Peter, thank you so much for your time and your wisdom today. I appreciate all that you've done for us and putting this together. All of you watching, if you would like to stay in touch with the Johnson Institute, please like us on social media, visit our website, sign up for our email list, and we will look forward to staying in touch with more programming in the future.
Happy Constitution Day.
Thank you.
Thank you. Thank you for having us.